Why are 3 of your tweets to Univision unavailable? I have no idea, and that is part of the fascinating story of Univision's claim against us, because when I then wrote out 10 tweets and then sent those tweets and then ThreadReader apped it, unrolled it into a ThreadReader thread, almost immediately people started telling me that my tweets were unavailable. And even the ThreadReader tweet that I sent the command for, even that was then made unavailable with 0 explanation. I feel like some kind of shadow banning. I mean, maybe none of these aren't the correct terms, but I feel like shadow banning is something that may have happened here, because there's no notice and you don't see it unless you, I don't even know how you would see it, because you can't. Like, even though it says this tweet is unavailable, click here to view, you click view and then it just disappears. Nothing happens. There's no display or anything.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
So this, then, is what I tried to send yesterday on Twitter, and ThreadReader did grab it before it disappeared, so I think everything's actually here. And I'll share this link in the description and in chat on our production show here. It says, from me, "Hey Univision PR team and Univision, let's use this false DMCA monetization claim as a teaching moment for what the public domain is." This is what I saw yesterday morning when I woke up. This is the live Mueller testimony with lawful masses that we did last summer. I want to say around July 19th or something like that. I think it was June, I'm not sure. And it says that my video cannot be monetized. There is a content ID claim on my video that doesn't affect my channel, not a copyright strike. Okay, so content ID tells me that it was identified by content ID. It doesn't tell me whether it's a manual claim or an automatic claim. Given the nature of the claim, it feels like it's an automatic claim, but either way, if they're making a claim to ownership of my copyright, I now have the right to take them to court and ask a judge for a declaratory judgment of non-infringement and some sort of declaration that I own what I said I own. So I feel I have a pretty strong case, but let's continue. It says that my channel's not affected, the video is still available, and the video simply cannot be monetized, and that the non-monetized video will somehow still make ad revenue, which will be paid to the copyright owner. The copyright owner here is Univision. Univision is the Spanish language television channel, who I'm sure also has a YouTube channel. And we've been receiving a lot of reports that people have been getting false claims from Univision, especially after Univision posts a video to its channel. So I'm guessing that maybe Univision has their copyright content ID settings set very aggressively, as if they own absolutely everything that is broadcast on their channel. But of course, that doesn't account for the public domain or for fair use, etc., etc., etc. So that is quite illegal, in my humble legal opinion, to just go around wantonly making copyright claims and then waiting to see who fights is a really terrible policy, which would obviously be like anti-viewer, anti-consumer, anti-content creator, and certainly against the spirit and black letter copyright law. So it is an audio-visual claim, which means that the audio and video matched, and it is monetized only in some territories. And I did watch the video from 2438 to 3211. It's all the Robert Mueller testimony. And you can see the C-SPAN 3 logo here in the bottom right corner. Okay, well, if I had just gone and used content from another creator like C-SPAN, that's not the end of the copyright inquiry. You can't just go use anything you see on C-SPAN. You have to be careful. Maybe I wasn't careful, right? You could imagine that somebody could make a mistake or something. Well, I remember this distinctly, and I was very careful, and I went and looked for the text on cspan.org that would tell me what my copyrights are. So that's this. C-SPAN's copyright and licensing policy. I'll also post this in the description just in case you're interested. This is where you would go, this link down here, to make a license inquiry. However, if you read through the text here, it says, under C-SPAN's copyright policy, a license is generally not required to post a recording of C-SPAN's video coverage of federal government events online for non-commercial purposes, so long as C-SPAN is attributed as the source. So we are arguably commercial purposes, but we have attributed C-SPAN. However, if that was the end of the inquiry, I might still at least inquire as to whether I required a license. But it does say down here, video coverage of debates originating from the chambers of the U.S. House and Senate is in the public domain and may be used without restriction. And that's important. C-SPAN is federally funded. They are paid by your tax dollars when they are covering federal government events on in the chambers of the U.S. House and Representatives. So the Mueller testimony was on the floor of the House of Representatives, and we did give C-SPAN 3 attribution by showing their logo and not blurring it out or something. I don't know why we would even do that. So I don't see any reason why we needed to either pay C-SPAN or pay Univision for that video. Yes, and that's important. It wasn't C-SPAN making the claim. C-SPAN is publicly funded, I say. I cropped out the video coverage section. I explain that Section 106 of Title 17 of the U.S. Code is where we get our copyrights from. I have the right to control the reproduction of the copyrighted work, the derivatives, the display, etc. So I have ownership of those rights. And DMCA 512F is this section that prevents anyone from knowingly making misrepresentations under this section, which I'm going to be arguing in court is them putting claims onto my clearly public domain C-SPAN material. And it says that if they knowingly materially misrepresent, that material is infringing, or that in the reverse case, that material was removed by mistake, that person shall be liable for any damages, including costs and attorney's fees incurred by the alleged infringer. So both parties need to make a sincere effort to understand their rights. They can be wrong about that as long as they are willing to testify, able to testify, truthfully, of course, as to how they came to form that belief. And as long as it is not a knowing material misrepresentation, knowing means knowledge, should have known, willful disregard for knowledge. Material means it's relevant to the core claim at issue. It's not something ancillary. You could obviously say, well, I'm representing that the sky is purple and maybe the sky is blue. Well, that might not really matter to the underlying copyright claim. So that's not material. And it has to be a misrepresentation. In this case, they're misrepresenting ownership of my copyright. I explain that they should remove the false claim immediately to avoid exposing themselves to further damage. They are welcome to reach out to me with an offer to settle, and I'm not going to discuss what terms I'm looking for, but when and if I ever make contact with them or hear from them, we will talk about what I would want monetarily and agreement-wise to prevent a lawsuit coming their way. So in the meantime, I've downloaded the video from YouTube because we wanted the exact copy of what was claimed. I'm going to register it. We don't register every copyright because it's $55 to register every copyright. We only make about $55 from every video. So we'll be registering the copyright, preparing to file an action. I am licensed in federal court, so I should have no trouble filing something. I might even hire my own attorney because Section 512F provides for their fees and costs as well. What it does not generally provide for is some kind of windfall. So I get my damages, but I don't get like $1 million or something unless that's the damage. I don't think that I'm being damaged by $1 million here. but at least not at this time. And no, you wouldn't normally say something like that, but really, are we really expecting me to be getting $1 million for this, and that somehow this Univision claim has prevented it? No. What about the YouTube escrow now? YouTube will hold the money in escrow. Well, it does say that the ad can't be, the video can't be monetized. So this means that even though we're now escrowing this non-monetized video, I would still want testimony and evidence and everything as to who had known what, when, and what their revenue was. I'll be able to get an accounting from them of how much revenue they made off of my video, and they'll have to turn that over, whatever that is. It could be a few cents, it could be a few dollars, it could be thousands of dollars, depending upon what the views are and the cost per meal and all that, CPM. So, ugh. So what I want to do, though, I don't just want this to be my claim. I heard that there were plenty of other copyright creators or content creators who had copyright claims or monetization claims or content ID claims from Univision. So there is something in the Federal Rules of Civil Procedure called Permissive Joinder. So here is Rule 20, the Permissive Joinder of Parties. Persons who may be joined. Persons may be joined in one action as plaintiffs if they assert any right to relief jointly, severally, which is not what we're going to be doing, or in the alternative, with respect to or arising out of the same transaction or occurrence. Okay, maybe this isn't any one same transaction occurrence, but a series of transactions and occurrences. So maybe Univision has made a bunch of legal claims on a bunch of different people's videos, and there will be any question of law or fact common to all plaintiffs. There will be a common question of law common to all plaintiffs. So that might mean that we could join multiple YouTubers who got claims from Univision in one action and go for a declaratory judgment that we are not infringing and get Univision to pay for the costs. And then it says here, neither a plaintiff nor defendant need be interested in obtaining or defending against all relief. The court may grant judgment to one or more plaintiffs according to their rights and against one or more defendants according to their liabilities. The court may issue orders, including for separate trials, to protect a party against embarrassment, delay, expense, or other undue prejudice that arises from a person against whom the party asserts no claims or who asserts no claims against the party. So when the judge feels it is appropriate, they might separate the actions. Does this mean that you can all be represented by one attorney? There's also a rule about concurrent conflicts of interest, so we might all have to get our own attorneys, or we might all have to file similar things or something separately and represent each party will need to be represented by either separate representation or pro se on their own. We would have to then evaluate whether any one lawyer could represent everybody. We'll talk to that lawyer because that's not going to be me. I'm going to be one of the parties. I don't want to be a party and be the lawyer for everybody because that would just be like two compound problems. You know, he who represents himself as a fool for a client. And then if I'm going to do that in the same thing and have a concurrent conflict of interest, I'm just opening myself up to all sorts of problems. And here, if we win and they really did have some sort of knowing misrepresentation, or the judge says they should have known, which is going to be my argument, if they say that the content ID claim, oh, well, it's automatic, so we don't know. Well, you should have known, considering how many years they've been operating content ID. We all know what it does now. There's no reason to believe that they don't have either willful ignorance of it, or they should have known, or they actually do know. So if you would like to be part of that, I will definitely put together a list of people who have said that they would like to be part of it. So reach out to us. My business email might not be the appropriate place. So reach out to my personal email. We'll use the Lawful Masses one. business@lawfulmasses would be a good one. That way it's not the lawyer email and it's not my personal email. It's business@lawfulmasses. Reach out to business@lawfulmasses if you have received an unresolved claim from Univision and would be interested in finding out whether we can all file an action. It would involve registering the copyright on the videos that were claimed, because that's the law. The law in the US is now that you have to register the copyright. The registration must be granted, and we don't have the Case Act yet, so we can't do it through the Case Act either. We have to go to federal court. But that's what we're facing. And I think that's a ripe claim. I think that's ready for adjudication. And I think we should come on strong with Univision, because this stuff really bugs me. This little content creators have to wake up and deal with this en masse sometimes. You'll have one of these larger organizations like Univision who get a content ID claim visited upon thousands of creators, or sometimes one creator dozens or hundreds of times. And does Univision ever make it right, or does the claimant ever make it right? I have hardly ever heard of them making it right and restoring the victim to the place they were before they got the claim. So we're going to explore this and see what happens. It's going to be slow. This is not going to be an action-packed court thing. This is more so going to be, we select the right court, we select the right parties, if any more than me. We might do it alone and just explain to everybody else how it works. Or maybe people can join in after they see whether our effort has been successful. Again, none of that is legal advice. If you've got a claim, I'm not necessarily willing to represent you, so you should talk to your own attorney about that. But you might want to tell them that this will be a 512F claim and that they should get their attorney's fees paid for if we win, and it was a knowing material misrepresentation. So what do you think of that? Let us know your experience with Univision, with false claims in general with Univision, or false claims in general with anybody, and talk to us about your thoughts about them using Content ID to claim public domain material. Is there some argument that this isn't public domain? Was that license clearance website from C-SPAN not clear that House and Senate chambers debates get public domain, escheat to the public domain right away? I think it was perfectly clear. It seemed to be clear last summer to me when I did the coverage. So yeah, they have to mark it as their own original content. And since that part is not, I don't see how they can sustain any sort of defense that they didn't know. They know that they're getting public domain content and then marking it as they own it. And I don't see how they have a way out of that. Anyway, let us know what you think about that in the comments below. We will maybe find another attorney and get an opinion as to how many people or what people could be joined as parties. If we find someone who's willing to represent more than one, or if we find more than one attorney. If it gets to the point that we're ready to do all of that, I will also reach out to my various lists of colleagues to see who would like to be involved with that.
I'm just wondering, on the back end, when you, is the process for Content ID automated such that YouTube assumes anything that you put on your YouTube channel is copyrighted by you and therefore, goes and seeks out copies? Or is it something where you have to select the videos and say, this right here is copyrighted? Nobody else can use any part of this.
We have some version of Content ID protection on our channel. When one of our videos gets identified as being uploaded by somebody else, it shows up on our copyright tab in the new studio interface, and we can then choose what to do with it. We can view the alleged infringing copyright infringement and then choose what happens with it. Maybe Univision has a button where they can say, always do this or always do that, or maybe sometimes do this or sometimes do that. And then, of course, they probably have all the manual claim buttons too. So in my case, I look at how the content was used, and so far I have not taken down anybody else's video except that one that Abdul posted on World Star Hip Hop without a license. right now we're also trying to figure out why Viral Hog is putting our video on Facebook, but yet not compensating me in any way for it. I'm aware that Facebook does generate ad revenue now, and so why are we not getting any part of the ad revenue from Viral Hog on Facebook? That's another one, but that's not a dispute I'm ready to go to court yet over. I have a license agreement with them, and I'm going to follow through with the contract remedies for that, because that's not copyright infringement if I have a license with them. So if they are using the automatic content ID system and marking their entire video as fully owned by them, I think that crosses into a knowing misrepresentation territory.
It also seems like Univision might be the type of channel where if they're regularly, posting or broadcasting things from Congress and other sort of news coverage like that, then they should be aware of what's in the public domain and what they can claim for themselves, and that it would only be their unique contribution to the broadcast that would count as copyright.
So here's Univision. Let me go to their videos tab. Now, I'm not the world's greatest reader of Spanish, but I don't see Mueller testimony. Is it Kurt Mueller? No, it's Kurt Mueller, and it is Robert Mueller. I'm so bad about this. I don't see the Mueller testimony on here. So where in the world do they say they own it anyway? At least if it is on here, it's not broken out into its own thing. I can search their channel.
It would have been from the summer, right?
Well, that's when I did it, but the claim was just came in yesterday. The nearest thing with the word Robert or Mueller in it is from 7 or 8 years ago. Maybe it's on a different channel or something. I don't know. Congress could drag Univision in to explain themselves. Yes, how about they drag me into Congress too, so I can have a few words with them? It would be an Eric Cartman moment. I'm not sure I'd be answering the questions they asked so much as the questions I asked. I'd be answering for them. I'd use it as an opportunity to make a public statement. But yeah, definitely spread this. Reclaim the Net has already done an article about this, which I thought was really cool, raising awareness. Univision has not responded to me. It is the weekend. It is a holiday weekend, but then they also claimed me on a holiday weekend, so I don't have a lot of sympathy for them. I'm keeping track of my time and my expenses, and we will definitely be asking them to cover that. This is ongoing. This happened with our Katy Perry video. I mean, heck, I have half a mind to just include them all in one lawsuit, that these false claims cannot continue, and I would like an injunction against YouTube from making further false claims. I don't know that I can get an injunction against YouTube from making further false claims, but it is YouTube's tools that are being used to make these false claims, and YouTube refuses to fix it by compensating the falsely claimed victims for the false claims. YouTube has started to do the escrow thing just recently, and that's the only reason why it might not be financially viable to make these claims. So what they're doing is taking further reasons away from you to sue, even though you have an underlying copyright. But they're trying to make it so that if you're not that damaged, then oh well, it's just a minor inconvenience. But it's not a minor inconvenience when it happens over and over and over again. It's death by 1,000 cuts, and no one cut is actionable? I don't think so. So we'll go after Univision, and I don't expect to stop until we've been properly compensated. I will probably go no further than that. And I can't promise any terms or anything, but I'll be fighting for a non-confidential settlement, so that others can see what they can do and get if they follow the same pattern with their attorney and follow through with it. You'll also see if I fail. I'm perfectly happy. I'm not going to be like happy to fail, but rather the concept of trying and failing is something that we need to embrace as a society, that you don't learn without trying, and you can't try without risking failure, and that failure should not be the death of anybody's business or person, because they simply tried sincerely. Certainly, I'm not talking about like death-defying stunts or something. I'm talking about copyright claims here. There shouldn't be anything wrong with taking these people to court and trying. What I'd like to be is maybe we'd like to blaze a trail, be the example, because how many people actually pursue these things? Very, very few. When I see even major channels with copyright claims, I offer to represent, and I'm very unhappy with the response. The responses are always, oh, well, it's just too hard to sue, it costs too much money. And that's everybody's response. It's a tough situation. That is our show, everyone. Thank you for joining me. I am Leonard French, your favorite copyright attorney. I am looking forward to the new year, and we'll probably do something like a year in review live stream on the 31st, where we will try to look at some comments and stories and things and go over it all for maybe another 2-3 hours and hang out. I think that sounds like fun. Do you think that sounds like fun? All right, well, she's gone. So thank you to our supporters on patreon.com/ljfrench and sponsors.com/law. At the $50 level for the month of December, thank you to Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Blackleaf, Joe Tyson, Benjamin Hitov, Stephen, Rumble in the Bunghole, and Cute Grills in your area. And thank you to the $5 plus supporters who will be in the description below and crawling on the screen in front of me. I wish everyone a very happy New Year's celebration. We're going to the Efteling, which is a amusement park in the Netherlands, and I'm very grateful to Kaylee's family who bought us tickets. We're gonna drive there tomorrow and spend the day there, so maybe we'll have some good pictures and video for you from the Efteling. Thank you very much for joining me. I'm Leonard French, your favorite copyright attorney. Love you all. Bye. All right. Of course, it's raining outside, so we don't know if it will be closed for rain or whatever. But this is his last day, so this is the last chance to go. So we are in the first class cabin, which is really nice. It really was. It's not that first class on the train really isn't that expensive. I think it was €10 a ticket for the $5.40 per leg. Okay. Did we get? Oh, we already have tickets to Luxembourg, though.
Yeah, this is from Luxembourg.
Okay, cool. Oh, we'll see. Of course, it focuses on the raindrops. Of course it does.